You can hear us and see us fine? Thank you.
Well, good morning and welcome to our virtual Supreme Court. This is our third go-around with this technology, and so far we've been very pleased. Should we have any kind of technical glitch, we'll take a recess. So if you're having a hard time hearing us, let us know. We'll attempt to get it fixed. Just a few words before we get started. We found that it's helpful if, when you're not arguing, if you'd please mute your microphone. Also, it's probably helpful if you also shut down your video when someone else is, or when the other side is answering. The members of the court will maintain our video at all times during the proceeding, although we will try to remember to mute our microphones as well when we're not speaking. If a justice has something that he or she would like to say, that justice will raise his or her hand, and that's not a signal to you necessarily that you need to stop talking right then, counsel. Just that once you've completed your thought, a justice has a question. Sometimes it looks a little bit like we're the students hoping that you'll call on us, but that's not what we're doing, and you need not ask us to speak. Just once you conclude your thought, that justice will begin. Let's see, what else would be helpful for you to know? Oh yes, as we've indicated to you, and we'd like to try allowing you 3 minutes of uninterrupted argument at the beginning of your presentation. You need not avail yourself of that if you prefer that we jump right in with questions. But unless we hear otherwise from you in your presentation, we're going to attempt to observe that. So with that, we are calling the case of in re adoption of BH, and I will ask that counsel enter your appearances.
Julie Nelson for appellant father.
Welcome, Ms. Nelson.
Jessica Kauser, co-counsel on behalf of the appellees and adoptive parents.
Welcome to you, Ms. Kauser. You're probably both aware of this, but although we have allotted you a time period in which to make your argument, in the event a justice is still asking questions at the conclusion of your time, you may continue to respond. So don't worry about your clock at that point. And it is also the case that reply time will be reserved. In other words, should you extend your time in your principal argument, if we are still asking questions in that argument, it will not cut into your reply time. So with that, let's begin.
May it please the court. Thank you. Julie Nelson for appellant father. Before turning to the legal issues, I would like to emphasize 2 critical facts and clarify the relief that we are seeking. The 2 critical facts here are, first, that this baby was not born in Utah, and second, that we are talking about a married parent. Now, to be clear, it could be a married parent or a divorced parent or any parent who has otherwise preserved his or her parental rights. And it could be a man or a woman, because the law treats married parents, mothers and fathers, equally once they have preserved their rights. We are not talking about a putative father. The relief that we are seeking is for this court to conclude that Utah did not have the authority to exercise jurisdiction and that this should be a Montana case. Any next steps, whether that's another adoption act, another termination proceeding, or any other proceedings, need to take place in Montana pursuant to the Icpc and the UCC-JEA. Now, the Court of Appeals has already set aside the adoption. We are asking you to override their decision that it should be remanded and determine that it should be a Montana case. This may be a big ask, but this court has repeatedly said, and I would point you most recently to the first couple paragraphs of the In Re BB, which was a very fractured opinion, but everyone agreed that even though adoption cases are heartbreaking and gut-wrenching, the best interests of the children can only be served by following the rules and the procedures that are in place. With that, I will turn to the ICP, and you can ask questions. That's a very interesting 3 minutes. The Adoption Act states that the petition for adoption and also the decree shall state that the requirements of the Icpc have been complied with. That's section 78B6-1071. They have been complied with. And in turn, the Icpc requires that before sending, the sending agency, which is here, the mother, provide the identity and the address of the parents. That's 62A 4A 701, Article 3, subsection 2B. Well, this one didn't. The Icpc form did not provide the identity of the parents. The Court of Appeals agreed and set aside the adoption. But what happened next is the problem. This problem cannot be fixed in the Utah courts because Montana did not have the complete information that it needed to make a decision under Article 1 of the Icpc. Adoptive parents have argued that there's a cover letter that suggests that Montana did have that complete information. I've never seen that cover letter. It's not in the record anywhere. And I'm not familiar with an appellate case that remands for new evidence to be introduced. But even if it were, it's difficult to believe that Montana approved the Icpc form knowing that there was a legal father. And it's also interesting in record page 13.
Could I ask you a question?
Yes.
So what obligation, if any, did trial counsel have to raise an objection about the lack of a finding of compliance with the Icpc in the decree?
Well, I think that the Court of Appeals has already addressed that by agreeing that the Icpc, the trial court failed to make that finding, and that on this record, it could not be. That's the reason that the Court of Appeals set aside the decree.
Yeah, but that's not my question. It's really a preservation question, and whether so it seems like your concern is that the adoption decree itself did not indicate that there was compliance with the Icpc.
Right.
And so you have some concern about the statements that were made in the decree. There's at least a vague statement in the decree, at least implicitly suggesting that there was compliance with the Icpc. And I'm wondering if the concern was, well, that may not have been correct, may not have been accurate, or may not have been complete, what was stated in the decree. Was it not incumbent on trial counsel to file some sort of post-decree motion asking the district court to clarify this? And then at that point, all this business about was there some cover letter or all these other details could have been worked out. But if trial counsel didn't raise that, isn't there a preservation problem?
I will need to check, but I think that it was preserved. But if it was not raised specifically, then people are not under obligations to file post-trial motions if the error is introduced in the final order. And so an appropriate remedy at that point is an appeal. They don't need to file that post-trial motion to ask for clarification.
I don't know if that's true as a general matter. I mean, if the very legal defect that you're concerned with is that the decree has to include language, seems to me the only opportunity to remedy that is in a post-trial proceeding. And I think there were some post-decree proceedings, as I recall, and I don't believe that in those post-decree proceedings, trial counsel raised this concern. You can correct me if I'm wrong.
The post-trial proceedings were very minimal. They were primarily related to jurisdiction, simply that there had been an extensive briefing of jurisdiction. And after the decree was entered and the Judge Faust just simply ruled that there was personal jurisdiction, a post-trial motion was filed to ask for clarification, and he rejected that. I don't remember if the ICPC was addressed in that, but I'm happy to look during opposing counsel's argument. But assuming that the error here is that the ICPC not only was not complied with, but on this record could not have been complied with, it was clear all through the trial that the identity of the father had not been announced. There was no dispute through trial that the identity had, the mother had misidentified the father, that in fact she was married. I mean, of course, that's what the entire termination trial was about. It hinged on understanding that the ICPC form was incorrect. And so there's really no dispute as to whether the ICPC form included the information that it needed to.
Ms. Nelson, what prejudice did your client suffer from the misidentification of the father on the ICPC form?
He suffered prejudice because this should have been resolved in Montana pursuant to Montana's laws. And if that was going to be a termination in Montana, then he would have been subject to the termination laws of Montana, not subject to the termination laws of Utah. Because what happened was the ICPC form, had it been filled out correctly, had Montana correctly understood that there was a legal father. And I also would like to point out that in Record 13, the mother tied her own relinquishment to the relinquishment of the biological father, who she had misidentified. But in fact, because he was not the biological father, mother's relinquishment also was not valid. But had Montana been aware that the child had a legal father in Montana, that child was not legally available for adoption. And Montana never should have, or I assume never would have, approved the ICPC. And any termination case...
Can I ask you about that point in particular? Because I think that's where I'm unsure as to how this works, and I wonder if you can help me. Because this seems to be a discrepancy between your position and opposing counsel's. You've made the assertion that if your client had been correctly identified on the ICPC form, Montana never would have allowed this child to leave the state. But I don't find any support for that on the face of the statute. And how would we reach that conclusion?
Well, Montana, like Utah, has a presumptive father statute so that the husband of a married woman is automatically assumed to have all legal rights. And Montana's code is actually even more clear than Utah's, that a child in that situation is not legally free for adoption. So in Montana, once they knew that the mother was married, that child was not free for adoption. In fact, even if mother's relinquishment had been appropriate, had been valid, then the only person who had all 100% of parental rights in this child immediately switched to father, because this child had two legal parents at birth, mother and father. And if mother relinquished, that doesn't leave the child free for adoption. That shifts all parental rights to father. That child was not available for adoption under Montana law. Now, it would also not have been available for adoption under Utah law, but that's not the point. The point is that it was not available for adoption under Montana law, and so Montana would not have been, under its own laws, Montana would not have been able to approve the ICPC for adoption.
Can I follow on to Justice Lee's question? So looking at the ICPC statute itself, I don't see provisions about that. That's one of the things I'm struggling with, is that I don't see provisions telling us of a remedy in the ICPC that affects jurisdiction or tells us that this proceeding should be dismissed here and started up again in the sending state. What within the ICPC statute can you point to that directs this, or is it Montana laws or regulations that you're kind of basing this specific remedy on, that this should be dismissed and go back to Montana?
Well, I can point to a couple of things. The first thing I would point to is the Utah Adoption Act itself, 78B61071, that states that the requirements have been complied with, and that didn't happen. And the Court of Appeals agreed that that didn't happen. Now, what happens next? Well, the Icpc, this is a question of first impression in Utah. We don't have any Icpc cases from this court. Article 4, I think, is where we should look. Article 4 of the Icpc highlights the possible penalties, and it states that such violation may be punished or subjected to penalty in either jurisdiction in accordance with its laws. So that would refer to Utah. But then it says, in addition to liability for any punishment or penalty, any violation shall constitute full and sufficient grounds for the suspension or revocation of any license, permit, or other legal authorization held by the sending agency, which empowers or allows it to place or care for children. Well, here, the sending agency is mother. And so penalty and punishment, any violation shall constitute full and sufficient grounds for suspension or revocation. And it's important that we do this, because if we don't do this, then we simply are allowing Utah's laws and personal jurisdiction to override the entire point of the Icpc. The Icpc requires in Article 1, if we look at Article 1, Subsection 3, it says the proper authorities of the state from which the placement is made, so that's Montana, this is one of the goals, may obtain the most complete information on the basis of which to evaluate a projected placement before it is made. But Montana didn't have that. And so if we say that in Utah, as long as the baby gets to Utah, then we'll fix any Icpc problems later, that's effectively overriding the Icpc. And frankly, we should probably make that clear under the withdrawal provisions or the severability provisions, that actually we will just allow any defects to be cured in Utah, in the receiving state, that we're not interested in enforcing the Icpc for the sending state.
Can I just ask one specific thing about the answer? In Article 4, the language of, so a violation of the Icpc should be grounds for the suspension of any license, permit, or other legal authorization held by the sending agency. So that's mom. What does that mean as being suspended or revoked? Because it makes a lot of sense if it's an adoption agency or some other agency. Are you saying that that means mom's relinquishment should be sort of suspended or revoked? Or how are you applying this to mom as the sending agency?
Yes, but mom's relinquishment should be, mom's relinquishment and placement should be suspended or revoked, at least until it can be resolved in Montana. Now, I suppose there's a possibility that Montana would choose to approve it with all the full information. I would say that that was a violation of Montana law, but if they did that, then, you know, the problem could potentially be solved. But that's up to Montana, what they're going to do with a adoption where there's a legal father intact. That's not up to Utah what Montana would do. So yes, I would say that it would be suspended. And like I said, in the record at page 13, mother actually tied her relinquishment to the relinquishment of the biological father, which at the time she perhaps assumed was someone different, but in fact is the father. So I would suggest that her relinquishment may also be void.
Do you have a sense of how the majority of states that have the Icpc deal with the question of how you remedy a defect? I mean, it seems like this, I mean, we may not have case law here, but it seems like this has arisen across the country. Do you have a sense of if there's a majority position on that?
Yes, and I think it has to do a lot with what the violation was and who committed the violation. I'm not familiar with any case nationwide where the Icpc the problem was misidentification of a husband. And I think that that's critical because it goes to the constitutional rights of the father. We're not talking about a typo. We're talking about failing to identify someone who has constitutional rights to this child. And I am not suggesting that the error was committed by adoptive parents. I've never suggested that. The error was committed by mother. And what we're trying to prevent here is other spouses or ex-spouses placing their children for adoption in Utah and failing to reveal who their spouse or the other parent is, and then just waiting and fixing it in Utah. So the case I would point you to is the Montana case of In Re TMM, where Montana did in fact undo the adoption. And I think that's significant because it's a Montana case. So that gives us some guidance as to what Montana would do if it had the opportunity to address this case as it should have in the first place.
Okay, so I have a few questions about, Justice Pierce, did that answer your question? I don't mean to cut off your answer. I have a few questions about the Adoption Act. And this actually goes a little bit more toward whether the UCC JEA applies. Well, first, what do you think is more important for your case, the Icpc or the UCC JEA?
I think that I don't have an answer to which is more important. I think that this court should determine that the case should be in Montana under both the Icpc and the UCC JEA. Either way, this is supposed to be a Montana case. Although we could prevail under either one. I think it would be helpful for guidance if this court would address both so that future cases know what to do.
So, leaving aside the question of what would be the home state under the UCC JEA, just looking first at the question of whether it should apply at all in this case. So there is the provision saying that it does not govern an adoption proceeding.
Right.
And I just want to point out a few provisions, and I'd just like you to address how you think these play out here. Okay. So the first one is you've got the definition in the UCC JEA of an adoption proceeding as any proceeding under 78B6 Part 1, so the Adoption Act.
Right.
Looking at the Adoption Act, so the first provision I want to ask you about, in the definition section, it defines, so 78B6 1032, adoption means the judicial act that A, creates the relationship of parent and child, and B, terminates the parental rights of any other person with respect to the child. This sort of gets to, I've been grappling with your argument that the UCC JEA clearly applies to a termination proceeding, but what do you do when you have a termination proceeding joined with an adoption? And this definition is sort of interesting because it's including in the definition of an adoption both the joining of the parent and child relationship, but also the termination of anyone else's rights in the child. So could you address that provision?
Yes. So let's look at Section 112 and Section 133. Section 112 in particular, Section 112.5, so 78B6 112.5 describes 5 different kinds of termination. Mm-hmm. And A through D all address the sorts of terminations that are under the Adoption Act. You'll notice that all of the cross-references stay inside of the Adoption Act, except for D, which goes to the Paternity Act and basically decides that a man isn't the father anyway. But what we're talking about here is subsection E. Subsection E is different. Subsection E is the termination of somebody who has preserved parental rights, like a married father, and who has not relinquished them. And that subsection leads you out of the Adoption Act and into the Termination of Parental Rights Act. So the individual's parental rights are terminated on grounds described in 78A, Chapter 6, Part 5. That's the Termination of Parental Rights Act. You see the same language in Section 133.1, which talks about terminating the parent's rights pursuant to the provisions of this chapter, which could refer to A through D, or subsection E in 112.5, which now refers to 78A, Chapter 6, Part 5, Termination of Parental Rights Act. And I would note that the record here at 751 shows that this man's rights were terminated under the Termination of Parental Rights Act, which makes sense and is consistent with Sections 112.5E and Section 133. So our argument is that the Adoption Act includes several kinds of termination, But this particular type of termination is expressly indicated in the Adoption Act to lead out of the Adoption Act and back into the Termination of Parental Rights Act. And we know that the UCC-JEA governs ordinary terminations. That's under 78B13-201 combined with the definitions in 102. So our argument is simple. It's simple, really, that the UCC-JEA doesn't apply to adoptions except for the terminations described in 112 and 133 that lead you directly out of the Adoption Act and into the Termination Act.
There are a few provisions in the Adoption Act that I've been kind of puzzling with in connection with this argument of yours, because I think this is a difficult question. So it looks like some provisions in the Adoption Act deal with the issues of a state having jurisdiction that sort of supplant the UCC-JEA in a way. They have their own provisions. The Adoption Act does. So in 1054A of the Adoption Act, it seems to explicitly kind of try to create jurisdiction over an out-of-state parent, even a legal parent. It says, the minor's presence in Utah confers jurisdiction on the court as to an out-of-state parent if that parent has been given notice per the URCP. So there's kind of this specific personal jurisdiction directly talking about an out-of-state parent. And 1055 says that service of notice on that out-of-state parent means there's personal jurisdiction now as long as the child, the minor, is present in Utah. And that's interesting to me that the Adoption Act, it doesn't specify this is only unmarried biological fathers. This seems to be discussing any out-of-state parent and saying as long as this child is in Utah, as soon as this out-of-state parent gets served, there's personal jurisdiction. How do we read that? That seems like it's sort of in place of some of the UCC-JEA provisions.
Okay, so let's go back to Section 4 first. It includes the words, it shall confer jurisdiction on the court in proceedings under this chapter. So I would hang my hat on those words and say that going back to 112 and 133, we are not talking about the sort of termination that is a proceeding under this chapter. Instead, we are talking about the sort of termination that is a proceeding under the Termination Act. So that's how I would respond to subsection 4. As far as subsection 5 goes, service of notice shall vest the court with jurisdiction over the person served in the same manner as if the person served was served personally within the state. Well, this goes to the point of personal jurisdiction, but the UCC-JEA itself says that personal jurisdiction is not sufficient. So to the extent that these two are in conflict with each other, then I would say that that simply suggests that perhaps the statute is ambiguous and it should be rejected under absurd consequences. Or I suppose if this court were to determine it were not ambiguous, but what the Court of Appeals says, then it should be rejected under the absurdity doctrine, because it's simply absurd to think that legislature has created this loophole where a married parent or a divorced parent can get around the UCC-JEA by dropping their child off in Utah, well, sending the child across state lines, and that the UCC-JEA won't apply anymore. This encourages parental abductions. It makes it so that any legislative amendment to the Termination of Parental Rights Act or to the Adoption Act simply guts the UCC-JEA and makes it so that we're not following the UCC-JEA anymore.
Can I ask you, Ms. Nelson, why didn't you just raise these concerns in a motion to dismiss for lack of personal jurisdiction? And perhaps combine it with a concept that your client is an indispensable party under Rule 19, and therefore this case has to be dismissed and refiled in Montana.
Well, I didn't do it because I wasn't trial counsel, but...
Well, when I say you, I mean your client.
I understand that father intervened because under 78B6 110(6), he's obligated to intervene. In fact, if he doesn't intervene, then he forfeits all rights and he can't he can't become involved in any other action.
Sure, but my question is, why not intervene for the limited, special purpose of challenging personal jurisdiction and asserting that the only place in which this case can properly get litigated is in Montana? I actually think you might lose that motion, but it seems like the premise, whether you win or lose, I guess I don't know, but it seems like the premise of a lot of what you're arguing is we have to read these statutes in your way, otherwise your client doesn't have any avenues, and I'm just not sure that's true. Why isn't the avenue the kind of motion that I mentioned?
Father did challenge personal jurisdiction. It wasn't in a motion to dismiss, it's true. But he did lay it out in a personal jurisdiction. There was
that's not before us, right? I mean, that whatever argument you made on that wasn't raised on appeal to the Court of Appeals and isn't presented to us on certiorari. You aren't asserting that the district court lacked personal jurisdiction against your client in this case.
That's right. We've asserted that Utah didn't have the authority to exercise jurisdiction under the UCCJA or the Icpc, and the personal jurisdiction doesn't affect that. And we see that through the UCCJA, which expressly states that personal jurisdiction is neither necessary nor sufficient. So if we're right that the UCCJA applies, then the personal jurisdiction question evaporates. Personal jurisdiction doesn't override the UCCJA if the UCCJA applies. And I think that makes sense because, again, it just changes the home state question. It effectively eliminates. If personal jurisdiction could override the home state question, then there would be no point in having a home state analysis. Does that answer your question?
It seems like under Navarro's, there's a good argument that there is no home state here.
I would address that. So I think we should look at the definitions of home state, which is in subsection 7, combined with the definition of persons acting as a parent in subsection 13. So we're talking about 78B 13, and the definition section is 102. If you go to subsection 7, we're talking about a child less than 6 months of age because the termination proceeding was filed when the child was only 5 months old. So subsection 7 says, in the case of a child less than 6 months of age, the term means the state in which the child lived from birth, so clearly not Utah, with any of the persons mentioned. Now, if we go to subsection 13, then persons acting as a parent means a person other than a parent who meets 2 criteria. One, they have had physical custody of the child or has had physical custody for a period of 6 consecutive months. And has been awarded legal custody. Well, the adoptive parents had not had physical custody for a period of 6 consecutive months when they filed the termination proceeding when the child was only 5 months old.
Ms. Nelson, isn't there an ambiguity about what lived means in lived from birth? I mean, if lived means were you alive, then yes, the child lived from birth at some period of time, certainly in Montana. But if lived from birth makes reference to some sort of residency, something somewhat more permanent. I think this is what some of the courts in other jurisdictions are getting at when they talk about putting some sort of time component on living. I mean, if someone asks me where do I live and I'm on vacation in Hawaii, it wouldn't be an accurate use of the English language to say that I live in Hawaii just because I'm alive and I'm in Hawaii in a hotel. So do you see so what's the better understanding of if it talks about lived with a parent or person acting as a parent, doesn't that reinforce the idea that it has reference to living on a somewhat more permanent basis than simply just being in a hotel room for a few days?
Well, that might go to saying that child has no home state, but if child has not Utah's the home state, Utah can't become the home state because 6 months hasn't passed. So either Montana's the child's home state or potentially child has no home state. But if child has no home state, then it's only because of subsection 208, which is the unjustifiable conduct provision that talks about a parent. In fact, I will turn there. Subsection 208 says that if a court of this state has jurisdiction under this chapter because a person invoking the jurisdiction has engaged in unjustifiable conduct, the court shall decline to exercise its jurisdiction unless 3 criteria are met. And when we look at the comments to subsection 208 in the Uniform Act, we see that this is the exact type of situation that they're trying to guard against. A parent moving a child outside of a state simply to forum shop, simply to get the child into a state where a different set of laws will apply. The UCCJA is supposed to guard against that. So even if child has no home state, then I would say that Utah is obligated to decline jurisdiction under subsection 208, and subsection provision 2 of 208 tells you what to do. If a court of this state declines to exercise its jurisdiction, it may fashion an appropriate remedy to ensure the safety of the child and prevent a repetition of the wrongful conduct, including staying the proceeding until a child custody proceeding is commenced in a court having jurisdiction. So I would say there that the only state that has jurisdiction without any unjustifiable conduct is Montana, because that's where the child was born. That's where the child would have stayed had it not been brought to Utah. So under provision 2 here, this court can stay the proceeding until a child custody proceeding is commenced in Montana, and then the regular provisions of the UCCJA may apply. Now, I'm the first to acknowledge that under the UCCJA, Montana has certain avenues to send the case back to Utah. But that, again, that's up to Montana. Utah does not have the authority to do that on Montana's behalf. And I would point out that there is a divorce proceeding in Montana. I don't actually know the current state of it, but when we were drafting the briefs, there was a divorce proceeding in Montana and custody was being disputed there, but Montana was prevented from making any sort of determination over this child because Utah has jurisdiction over it. So the point is that Utah could stay the proceeding, allow the adoptive parents to file a child custody proceeding in Montana, invoke Montana's UCCJA jurisdiction, and then see what Montana does at that point. It may choose to return it to Utah, or it may not.
I want to just ask one quick thing about the definition of person acting as a parent when we're talking about home state. So it looks to me in 102.13, the definition of person acting as a parent means a person other than a parent who has physical custody of the child or has had physical custody for a period of 6 consecutive months within 1 year immediately before the commencement of the proceeding.
The question is about what does the or mean? Whether the period of 6 consecutive months picks up on the has physical custody of the child.
Yes, or is it just anyone who has physical custody of the child?
My understanding from the comments is that it's supposed to be has or has had physical custody of the child for 6 months, and the reason for that is to allow any other parents to take action.
Okay.
And that makes sense, because if the person had physical custody of the child for an hour in what amounts to a kidnapping situation, that doesn't make sense, that's what they would be getting at. If there are no further questions, I'm well over my time, and I will.
Yes, thank you, counsel. We'll now turn to Ms. Kauser.
Hello, good morning.
Morning.
I'm going to take the first minute of my time to quickly thank both counsel for the appellant as well as the court support staff, including Nicole Gray, and everybody who has put time into making this oral argument calendar possible today in light of the current pandemic. And I appreciate all of your patience and understanding. I have taken every precaution, and yet I am still terrified. I can hear lawnmowers nearby, and I'm terrified that somebody would just pop in. So I appreciate your patience, and if you have any trouble hearing me or there's any distracting sound, please let me know, and I will try to move to a different space. Also, my clients are so grateful that this date was not postponed and that I could proceed on their behalf today, because the child who is the subject of this case, baby H, is not a baby at all. She is 4 years old. And there has been constant litigation throughout the entirety of her life. And I know that the justices of this court carry the very heavy burden of balancing the rights of the parties and the integrity of the law and the best interest of this little girl. So even if this process is imperfect, we are so grateful to have it and are glad to be addressing you today. Chief Justice mentioned that I could invite your questions, and I absolutely do. If you want to start with questions, you can do that and interrupt me anytime. I don't need the 3-minute buffer. Thank you. Okay.
I do have a question for you, Ms. Kaiser, if you don't mind. So with respect to the question of the applicability of the UCCJEA, it seems to me that your strongest argument is the language in the statute that says that this these provisions don't apply to adoption proceedings under this chapter and part, and that this chapter and part includes contested adoption proceedings. I think that's your strongest point there. I want to ask you, though, about a possible counter argument. Under Section 112, a petition to terminate parental rights, it says may be joined with a proceeding on an adoption petition or filed as a separate proceeding before or after a petition to adopt the child is filed. So let's say that a petition to terminate parental rights is filed before the adoption petition. And so at that time, it's just a freestanding termination petition. I assume that is subject to the UCCJEA, right?
Yes, I would agree that it is.
And how do you deal with that? Doesn't that therefore suggest that these are separate proceedings? And doesn't the language that I just referred to, that the petition may be joined with a proceeding, the petition to terminate, may be joined with a proceeding on an adoption petition, doesn't that suggest that these are two separate proceedings? And wouldn't it be strange to say that if the petition is filed independently and before the adoption, the termination petition is filed independently and before the adoption petition, it's subject to the UCCJEA, but if it's filed concurrently or after, it's not? That would be odd.
I don't find that to be odd or strange at all. If you consider the purpose for filing a petition to terminate parental rights, in this context, we're talking about filing for the purpose of facilitating an adoption. If you were to file a petition to terminate parental rights absent an adoption, first of all, I'm not sure what the permanency plan or purpose for that child would be, but it's not for the purpose of facilitating adoption. Under basically the common sense principles, but also under multiple statutes, it is necessary to terminate parental rights in order to allow an adoption. And so a termination within the context of adoption is different than a termination that might be brought separately for some other reason.
Would you, and this is following up on your question, Justice Lee, so if in this case, for the purposes of an adoption, before filing the adoption petition, the adoptive parents filed a petition for termination in the district court, not in the juvenile court, in the district court, and did that prior to filing the petition for adoption, but told the district court, we intend to adopt, we'll do that as soon as we're finished with this petition to terminate. Would that be a petition under the Adoption Act or under the parental right? I'm forgetting the name of the other act, but the Termination Act.
Yeah, the Termination Parental Rights Act. So I don't think that the district court would have jurisdiction. I believe that to file a petition for termination of parental rights, I need to look at that statute, but I believe that the juvenile court would have jurisdiction, exclusive jurisdiction over a petition to terminate parental rights absent an adoption.
Could I chime in on that, Ms. Kauser? So the provision that I was reading from Section 112 says a district court has jurisdiction to terminate. This is 112.1. has jurisdiction to terminate parental rights in a child if the party who filed the petition is seeking to terminate parental rights in the child for the purpose of facilitating the adoption of the child. So I wonder if what you just said is perhaps wrong, and if all you have to do is say the purpose of my termination petition is to facilitate an adoption, and that if you do that, then the district court has jurisdiction. And then just looping back to what I was saying before, which is related to what Justice Peterson is asking you, doesn't the language of 112.2 suggest that these are two separate proceedings, since they can either, the petition to terminate parental rights may either be joined with a proceeding on an adoption petition or filed as a separate proceeding. If it may be filed as a separate proceeding, doesn't that sort of negate and override the language that says adoption proceedings are outside of the UCC JEA by suggesting that, well, the termination proceeding is just separate. It's related and certainly a necessary step, but it's separate proceeding from the adoption proceeding. Is that wrong in your view?
Yeah, I guess I don't understand why. So if a petition were filed for the purpose of facilitating an adoption, then wouldn't it meet the section, the 112.1 language that you just read? So whether it was filed or not, whether it's filed separately or not, if it references that the purpose is for facilitation of the adoption, then it wouldn't fall. Then it wouldn't fall. It would be defined as the Adoption Act has defined it as being brought within the Adoption Act or for the purpose of the adoption. I can think of no scenario where you would file a petition to terminate parental rights in the district court if it wasn't for the purpose of facilitating adoption. So,
but here's the thing I'm struggling with. I'm going back to the language of the UCC JEA, which says two things. One, adoption proceedings, all sorts of adoption proceedings are outside of the UCC JEA, right? But two, a petition to terminate parental rights is within the UCC JEA. You agree with me so far? Yes. So now the question becomes, I think, can there be any such thing as a termination proceeding that facilitates an adoption that is separate from an adoption? And I guess I think the language of 112, I was leaning the other way for a while, but when I looked at the language of 112, it's 112.2 in particular seems to me to suggest that these can be and sometimes are separate proceedings. And that's the barrier I'm having. And if you can help me to overcome it, then that would be helpful.
They're not separate proceedings if one is for the purpose of the other, and one is actually necessary to the other. They wouldn't be separate They may procedurally be separate. They may have different case numbers, but they are if the petition to terminate parental rights is for the purpose of facilitating the adoption, and the adoption requires the termination of the parental rights of anybody who's established their rights, then they are inherently dependent on each other, and they both fall squarely within the Utah Adoption Act. And the purpose of filing that separate petition, if it's filed separately, is to facilitate an adoption. And I don't think so. I do believe, Justice Lee, that you're correct, that I may have misspoken, and that a petition could be filed absent an adoption petition. But if that petition to terminate parental rights said it was for the purpose of facilitating an adoption, then it would fall under the Utah Adoption Act. I can't imagine why anyone would do that. I think that the adoption petition would be also a necessary procedure. But in order to facilitate an adoption, finalize an adoption, the termination of the parental rights or the relinquishment of the rights is necessary and essential. And therefore, if it's being filed for that purpose, then it would fall under the Utah Adoption Act's exception from the UCC JEA.
Sorry, I was just looking at the statute. Am I going over someone else raising their hand? Let me ask you this, because in in looking at this question of whether the termination has its, even if it's joined with an adoption proceeding, does it still have an independent character as a termination that is subject to the UCC JEA in some way? In reading through the Termination Act, and I'd just like you to comment on this. So in reading through the Termination Act, it may be in 506, let's see. Okay, so in the Termination Act, 78A6, 506, nature of proceedings, it seems like there are some procedural requirements in the Termination Act that are different than the procedural requirements if you're doing a termination under the Adoption Act. So in 506, it talks about notice and nature of the proceedings, and it says that after the petition's filed, notice shall be provided to various people. It needs to indicate the nature of the petition, time and place of the hearing, right to counsel, various things. And then it says a hearing shall be held specifically on the question of termination of parental rights no sooner than 10 days after service of summons is complete, which makes me think maybe there's a summons is required here. And that's kind of different from the notice that is different than the notice that's required in an adoption proceeding. If you have a presumed father like you have here, his consent is required for adoption under, I think it's 120, section 120. So he'd get notice that's different than the notice that the Termination Act is talking about. He would need to get notice saying, you need to move to intervene within 30 days. And if you don't, here's everything that you lose. So is there a difference between a termination proceeding, even though in the Adoption Act, it refers to the grounds in the Termination Act? Is a termination proceeding under the Adoption Act somehow different than a termination proceeding under the Termination Act? Does that make sense?
I think so. I think the answer to your question is, first and foremost, the Utah Adoption Act references the Termination Act only in that the district court has jurisdiction to terminate parental rights on grounds referenced in and cites the section of the Termination Act. And so it's referring to the grounds, not to the procedure. But also, to answer your question, in an adoption matter, a parent who has rights, who has a right to notice and consent, receives the notice that you described, which is notice that an adoption proceeding has been filed and that they have a period of time to intervene. And once they intervene, or at the same time, if a petition for termination of parental rights is filed as well, they also receive a summons or notice of that so that they can answer that, because you're correct in that they are two procedures. There are two cases. In this case, filed within the adoption, the same adoption case, but there's a summons for the termination and there's a notice for the adoption. But I don't think that concludes. Justice Lee already, I think, touched on this. I'm not arguing that they aren't different, actions under the statute, but that they are inherently dependent on each other, and that the adoption case itself requires the termination case.
I guess let me ask it to you this way. Is the petition here being brought under the Adoption Act and its provisions, or is it being brought under the Termination Act and its provisions joined with an adoption?
It's being brought under the Adoption Act for the purpose of facilitating the adoption that is pending. And I don't see how it could be. I don't see how it could be interpreted any other way. It's brought within, it's joined, it references the case, it's the same parties, and it's required in order to facilitate an adoption. We have no other procedural process to terminate parental rights to facilitate an adoption. It's written into the Utah Adoption Act that that is the procedure and that's the process.
So here we have conduct that by the mother, not by adoptive parents, but by the mother, that, you know, she did put this child up for adoption in contravention of the rights of another legal parent. And that's just, you know, based on the conduct that happened, it's pretty serious. It even arguably is a criminal offense of custodial interference. What do you say? What could a father do? Are you saying, is there any remedy for a father in that situation to have his case heard in his state after conduct like this? What's the remedy if an adoption proceeding is brought in Utah? Was there any remedy for him and he just missed it?
I think ultimately, no. I think that the only remedy that may have been possible would have been for him to file a motion to dismiss in the beginning at the time of intervening and have and make his jurisdictional arguments then. But absent that, and I agree with what's been stated before, is that I'm not sure he would have prevailed on that motion even had he filed it. So at the end of the day, no. But my answer to that question is that his rights are still protected, whether they're in Utah or in Montana. He was given notice. He was invited to participate. He had the ability to defend himself, to present his case. He testified at his trial. And because it was in a different state, that doesn't mean, and that's been part of my frustration, is that is the argument that's being made a due process argument? Is a choice of law argument? The fact is that we have established in multiple cases here that a father who avails himself to this court and intervenes in a case, that Utah has jurisdiction over him for the purpose of an adoption.
Is it his intervention that creates that? Because I mean, if so, that does create a sort of catch-22. I mean, unless, as we were saying, unless the intervention is sort of for the limited purpose of seeking dismissal and saying that the case can only be litigated in Montana or something. I mean, that point about, you know, he's subject to jurisdiction because he intervened, that is a little bit of a catch-22 problem.
I understand that. I think that I would rely on the Hamilton case, which says absent a motion to dismiss, the continued participation in litigation is contrary to an argument later that there was no jurisdiction.
Yeah, I think that's a better point. Can I ask you about the Icpc before we run out of time? I need to understand better. Ms. Nelson gave us her view of the provisions of the Icpc in terms of, to me, the big question is prejudice and what would have happened. I'm just assuming for the purpose of this argument that the information that the Court of Appeals suggested might have be outside the record. I'm assuming that it's not there. And I'm just wondering what would have happened. Would the state of Montana have forbidden these adoptive parents from taking the child and transporting the child across state lines if the legal father had been identified?
So, first of all, there's no answer to that question. There's no basis for what's been argued is that the child wouldn't have, the Icpc wouldn't have been approved. In fact, I would point the courts, and I would ask the courts, honestly, if they haven't had the opportunity, I highly recommend a close reading of the Maryland case, which I discussed in our brief. It's INRI Adoption Guardianship number 3598. And that case is factually similar to this one, except in that case, the birth mother put on the Icpc 100A form that the birth father was unknown. And in that case, there was some confusion where apparently the adoptive parent's attorney called them and told them that their ICPC had been approved when it had not. And based on that information, they transported the child across state lines prior to ICPC approval. But the Supreme Court of Maryland in that case does a very lengthy analysis of this problem. And in that case actually addresses that as well. Each state under ICPC has their own rules as far as what their requirements are to approve the transfer of a child. I know of no case where, and the Maryland court as well, there's two Maryland cases, the one I've just cited as well as in readoption 10087.
Could I ask you, could I interrupt here and just, well, I see the chief had a question. Go ahead, Matt.
Okay, thank you, Tom. So Ms. Nelson argues the child wouldn't have been available for adoption at all if the legal father had been identified on the ICPC form. Why isn't that a good argument? Is it a practice? I mean, can we imagine that it's a practice of Montana to send children to another state, even in cases where there is a legal father and that legal father has not been adjudicated to be unfit?
Yes, and that's what I was about to say is in that Maryland case, both of those cases do a lengthy analysis of the ICPC, the history of it, and what the purpose of it is and why it should, or what should happen in the event that it is violated. And in it repeatedly, Maryland courts at least have recognized, as well as some of the other cases that I've cited, that the ICPC is not, the purpose of ICPC is not to protect parental rights. It was never to protect parental rights, and nothing in the ICPC indicates that.
Yeah, my question, I understand that point, but my question goes to the prejudice question raised by Justice Lee. As a matter of fact, is it fair to posit that Montana, even in the face of a legal parent who has not been adjudicated to be unfit, assuming they were aware of that information, would proceed to send the child to another state?
Absolutely, and it happens all the time. Typically, the ICPC agent stops that inquiry at making sure that the parental rights will be addressed in the receiving state, which is exactly what happened here.
How do we? I mean, what is the record basis for that assertion? Because I mean, you and Ms. Nelson just have very different views about how that would play out, and I don't know if we have any record evidence on it. And we have language in the ICPC that just seems really broad and vague as to how it's supposed to play out, and this seems like a big question.
That's one of the arguments that I made as to this issue not being right. I want to clarify that I believe counsel during her argument misstated why and how why the Court of Appeals remanded. The Court of Appeals remanded because the findings in the adoption said that all requirements of the Utah Adoption Act had been complied with, but did not specifically state that ICPC had been complied with. And that is contravened by the fact that the approved 100A form is in the record. And so it was remanded to the trial court to make a specific finding as to whether ICPC was complied with. And I would posit that the trial court at this point could simply use what is in the record, the approved 100A form, and make a finding that says, yes, ICPC was complied with. I suppose the trial court could also take additional evidence. There was no argument at the time and no reason for the trial court to have addressed the question as to whether the father's name on that ICPC form invalidated that form. Traditionally, if the ICPC agents in both states have signed that form, it's an approved form, and that is evidence of compliance with ICPC. And so as far to answer your question, also, there are places in the record that show and indicate that father was listed. I have referenced that there was much more, an entire packet that went to the Icpc agent that did identify the presumed father. And I know.
Could I ask you about the preservation question that I asked Ms. Nelson about? I mean, should trial counsel have raised this post decree, and is the failure to do so a preservation problem for the father in these appellate proceedings?
I believe that it is. We never had this question was never raised at the trial level. We never had the opportunity to prevent that evidence or to provide that evidence. Never had the opportunity nor reason to present that evidence and show that Icpc had actually been provided with the father's name. I would argue that it's not necessary. If Icpc approved it, then the adopted parents had complied with Icpc. But if that is a concern, if the question needs to be answered as to whether Icpc would have been approved with the presumed father's name, that can easily be answered on remand, as the Court of Appeals did, if the trial court accepts that evidence. Does that answer the question?
So in the adoption decree, in paragraph 12, it says Icpc forms from Montana have been filed with the court. Is that the only statement? Is there somewhere where it does say that it was complied with? Because
No.
I thought one of the defects the Court of Appeals was saying is we don't have a statement from the court that it was complied with, just that it was filed. And I understand father's argument that, look, this Montana may have signed off on the forms, but it was without information that the child had a legal father. And I understand the testimony in the district court that mother didn't know who the biological father of the child was. That doesn't matter if her husband is the presumed father. There's a person with legal rights in the child in Montana, and that information was not on the form, which is really troubling. And it seems difficult, unless it's clear Montana had that information somehow. It does seem like it's not much of a remedy to say now, 4 years later, well, give the information now. That's just a little problematic. Can you respond to that?
Yeah, so first of all, I would point out that the Icpc form 100A asks for the mother's information and asks for the father's information. Nowhere on that form does it ask for a spouse or ask what her marital status is, and that her testimony was consistent, and the court found credible that she believed someone else to be the father. And I know that the foundation of the argument and the foundation of the question that you have, Justice Peterson, is, well, there was a legal father. But the birth mother is not aware of Lord Mansfield's law and a marital presumption. There's no reason that she should be. We as lawyers understand that significant history, but she listed the father that she believed was the father. Oh my goodness, I'm sorry. Can we take a moment? There seems to be a problem with the power on my laptop. It's plugged in, but it says it's not. May I have 1 second? Sorry. Okay, I apologize.
No, don't worry about that. Those are just the kinds of problems we expect to counter. Par for the course.
Okay. And so I think I've answered the question in that she listed the father. And then as far as I think I've answered the question as to what the prejudice would have been. That frankly, if on remand we could have, or had the father preserved this question, we could have resolved that issue. And then finally, again, I want to be clear. I know that there's no precedent here. There's no administrative law or rule that we can point to that says what the ICPC agent in Montana's requirements are for approval and what the requirements in Utah are. Believe me, I've tried to find those and I can't find them. What I will say is that those Maryland cases that I cited reference several situations that are similar. Based on him being found to be unfit.
Thank you. That answers my question. Thanks.
Okay.
Thank you, Ms. Kauser. We'll now turn to Ms. Nelson.
Can you hear me?
Yes.
Thank you.
If I could start you off, Ms. Nelson, if we could go back to Justice Lee's question about the possibility of a limited intervention or limited appearance for the purpose of contesting jurisdiction. I'm wondering how that would have played out and why that would not have been a way or an avenue available to father to bring this to a head earlier in the proceeding, and if necessary, to seek some type of appellate review.
I would direct you to Utah Code 78B 13-2013. That's the part of the UCCJEA that specifically says that personal jurisdiction is not enough. So any attempt to move to dismiss for lack of personal jurisdiction is irrelevant to a question under the UCCJEA, because whether there is personal jurisdiction or there isn't doesn't make any difference. As far
and so as to, and I understand that point, and thank you. And so as far as contesting the UCCJEA jurisdiction, were there other avenues available to him to do anything beyond what he did to try to have this brought to a head earlier in the process and maybe seek some kind of appellate review?
I'm not aware of any way to have done it differently. It was certainly preserved, and I would also tack on here that the ICPC issue is clearly preserved at record 670. The ICPC issue is presented to the trial court, not in the context of a motion to dismiss, but definitely preserved, and was brought to the trial court's attention. And so for that reason, a post-trial motion on that issue would also not be necessary.
What was that site? I'm sorry. Can you just repeat the site?
Record 670.
670. Okay.
May I ask you a couple of questions, Ms. Nelson?
Sure.
All right. It seems to me that your subject matter jurisdiction question, at least with respect to the ICPC, essentially boils down to, because the provisions of the ICPC were not complied with, there's no child legally available for adoption.
Right.
As sympathetic as I may be to that argument, isn't that precisely the argument that I articulated in BB and lost on? The jurisdictional point I think that I made repeatedly in BB was that because the ICWA had not been complied with, there was no child legally available for adoption, and the majority held to the opposite. So I'm struggling with how you would distinguish the outcome in BB with the outcome that you're seeking here? That's question one. And question two is there really, to Ms. Kauser's point, is there an inadequate ICPC declaration here? Because the trial court did find the mother credible, and that she did list who she thought was the biological father on the ICPC declaration.
I would, for both of those questions, I would turn you to our reply brief at page 4, footnote 2. We've cited the ICPC regulations, and it states that the request packet accompanying the form shall include the consent or relinquishment signed by the parents in accordance with the law of the sending state. And the law.
So then you are presumed to know the law. Then is what you're suggesting.
Yes, ignorance is no excuse, and it's certainly no excuse for the ICPC people in Montana. If in fact the people in Montana knew that she was married, surely they are aware of the law.
I got it. What about the BB distinction?
I would say the same thing, that this Montana code clearly makes it so that the child was not legally available for adoption. In fact, the Utah code also requires not only the decree, but the petition make clear that the ICPC be complied with.
That doesn't quite do it for me, because I think the same was essentially conceded in BB. It was just that wasn't enough to defeat subject matter jurisdiction.
But we're not talking about subject matter jurisdiction. We're talking about whether Utah has the authority to exercise that subject matter jurisdiction. And here it didn't. I mean, it's simply the case that the Adoption Act requires that the provisions of the ICPC have been complied with, and they weren't. That's the doorway into accessing Utah's subject matter jurisdiction over adoptions, and it wasn't met here. If I could turn to, I have a couple more points on the ICPC and the UCCJEA. If I could turn to Justice Peterson's question about the UCCJEA, looking back at Section 78A, this is the Parental Termination Act, 78A-6-506, the section that Justice Peterson points us to, ties itself directly to the provisions of the Adoption Act that I'm referring to, 78B-6-1112. Just lashing those together even more tightly. And I would also direct you back to the record at page 751 to 752. This is the termination order, and it's issued under the Termination Act. It cites sections 506, 507, and 508 of the Termination Act. There is no question that Judge Faust thought he was terminating this man's rights under the Termination Act. And that is important because that meant that father was subject to the termination criteria of Utah law. If Utah had a different termination standard, or if the legislature amends it, then that means that all the parents in all the other 49 states are subject to whatever Utah's termination laws are. It's not a matter of being on notice that you have to come and defend yourself. It's a matter of being on notice that you're subject to the laws in Utah, a state where your child isn't and you've never been. None of us are on notice that we're subject to the parental termination laws of a state other than the one where we live. And that's my concern as far as the UCCJEA goes.
What was the first statutory cite you gave in the beginning of your point, the part of the Termination Act that attaches itself to the Adoption Act?
The one that you cited, 78A-6-506, it directly refers to 112 in subsection 2. You were talking about whether there were different requirements, but that same subsection 2 refers to the Adoption Act, 78B-6-112.
Was this petition brought under the Termination Act or the Adoption Act?
It was brought under the Adoption Act.
Okay. Does that matter?
I don't think so. For the reasons that I've explained, that I understand that the Adoption Act allows certain kinds of terminations, but under 112.5E and 133.1, the only way to get through that doorway is to go back to the Termination Act. You know, and Justice Lee was pointing out the inconsistency of having some terminations subject to the Termination Act and the UCCJEA and the others not, depending on what order you file your documents in. I would just suggest that one, confirms the plain language doesn't mean that, and two, if it does, it just adds to the absurdity of the situation. You've got this tiny window. As long as you do it this way, the laws don't apply to you. I can't fathom that the legislature intended that, and that's the key of the absurdity doctrine. Turning back to the ICPC, just one point I'd like to make. In the Maryland cases, and also I think in In Re BB, the parents were not married, and that makes all the difference. That's where I started, and that's where I'll end. When the parents are married or divorced, there is a different set of circumstances in play than when you have a putative father who has additional standards you need to meet. In the Maryland case, you had an 18-year-old with a one-night stand. That's very different than a husband. And as we explained in our reply brief, the Maryland case, in Maryland, they use a best interest standard. Well, they're allowed to do that in Maryland. But in Utah or in Montana, which is what we're worried about, in Utah, we know from In Re BB, and I will quote, to conclude, the best interests of the child in Utah can be served in no legitimate manner except in obedience to the policies and procedures mandated by law. So it is vital that the courts of this state, this court included, take care to ensure that adoption proceedings are as free as possible from fatal defects. That's the standard in Utah. If Maryland has a different standard, that has no bearing on this case. There are no further questions. I'll submit.
I would like to just ask you one last thing. This is sort of a preservation point. Beyond just the basic question of, so you've given us a site of when the ICPC was preserved, but I guess I'm wondering if the litigation in this case started out as a motion to intervene and father participating in this process and defending himself in a termination proceeding, but later on, arguments are made about the court's authority and the court's jurisdiction. Is that how it played out, or did father come in sort of immediately asserting you don't have the right to be doing this in Utah? And was this sort of laid bare from the beginning, or is this something that was raised after father lost his termination, lost at the termination hearing?
Well, I have 2 points. One is that in father's motion to intervene, he asked for custody of the child. So I think it's clear from the beginning that he was challenging this. And I think another factual nuance here is that father at the time that he intervened knew that he was the legal father, but it wasn't clear to him whether he was the biological father, and his desire to push forward may have differed, but a genetic test in Montana subsequently revealed that he was in fact the biological father, making him both the legal father and the biological father, and this couple has a sibling. I think that once father knew that there was a genetic test, that may have propelled him forward in terms of practicality of what happened here. But he did intervene and ask for custody right off, which was necessary to get his foot in the door.
Thank you, Ms. Nelson, and thank you, Ms. Kauser. We very much appreciate your arguments. And at this point, court is adjourned.
Thank you. Thank you.
Can we stay on for a moment?
Yes, let's stay on the line. So Judge Hagan will be joining us for this next argument. Should we take